So finally tonight, criminal justice reform at the legislature. 2023 was a pretty light year on that front, with a few notable exceptions. One measure that did get through was, or has been years in the making. Senate Bill 84 would have made it tougher to lock up probationers and parolees for ticky-tack violations like missing an appointment or failing a drug test. But despite a relatively easy path through both chambers, Governor Michelle Lujan Grisham vetoed the bill. Executive producer Jeff Proctor sat down with a prosecutor and a public defender to ask whether the governor did the right thing and the real problems underneath so-called technical violations.
Bennett Bauer, Marcus Montoya, thank you both for joining me here today.
Thank you for having us, Jeff.
We're here to talk about two gubernatorial vetoes on criminal justice reform bills. You each wrote an op-ed about those vetoes. Ben, you are a public defender. Marcus, you're a prosecutor. To the galloping shock of exactly nobody, you guys disagreed. So let's start with some basic definitions. Marcus, what is the difference between probation and parole, and what is the role of both of those things in the system?
All right, good question. And so probation, upon plea agreement or enter of guilt or finding of guilt at trial, you're going to have a sentence. That sentence can be probated, which means you're not going to be serving any time incarceration. That's the nuts and bolts of a basic understanding of how probation is going to operate. And then so you are on terms and conditions to comply with the court and be monitored typically by probation and parole. And if you violate those conditions, it's the discretion to potentially change your conditions or revoke your conditions of release and incarcerate you. Parole is when you have served time in incarceration and you're now released from that time, and so now you are under parole supervision by the parole board of the Department of Corrections.
Gotcha. So there are two forms essentially of state supervision outside of the incarceration context, right?
That's correct.
Gotcha. So for years, Ben, we've heard conversations about what are called technical violations. Marcus described conditions that you'll have, whether you're on probation or parole, and we've heard in interim committees and during legislative sessions about technical violations for years. What is a technical violation of probation and parole, and what are some examples of how you can do that?
Sure. Thanks for having me. So when you're on probation or parole, there are certain conditions you have to meet. Showing up to see your probation officer or parole officer, probably not doing drugs, not committing a new crime, things like this, things that are generally concerned with public safety. Technical violations are things that are less important. They still may be conditions and they still may be important, but it's things like missing an appointment or having a positive result on a drug test. So although you haven't hurt anybody, you may have done drugs and that showed up on a test. The way the system has worked traditionally is somebody gets accused of that and then they're arrested and held in jail until they get a hearing on it. That can take days, weeks, or even months. And in the meantime, there's all kinds of things that have happened to somebody that's in custody that we could talk about a little bit later. But the point of trying to handle technical violations differently is that you actually get to what you need to do with the person to address it rather than waiting for those days and weeks and months and all the damage that can do.
So the result of a technical violation or a standard violation of probation and parole is, or has been historically, in many cases, reincarceration, right? So I want to talk a little bit about, Marcus, from your op-ed, praising the governor's vetoes of these two bills we're here to talk about today. You mentioned that by doing that, by sort of getting rid of what would have happened with technical violations under SB 84, that the governor helped with community safety. So how does locking people up on these technical violations bolster community safety?
So I think there may be some misunderstandings in terms of use, right? So if I can go back to what you just said, Jeff, is a lot or many or most of these technical violations result in incarceration. Not necessarily. And actually, I would argue that they don't usually end up in incarceration unless there's a parole warrant for arrest to bring them in, like Mr. Bowers outlined. They do have to wait in jail until their hearings. So I'm not going to contest that, but if they're minor probation or minor parole technicals, there'll be a filing of a violation by probation parole, our office will review it, we'll file for a hearing, and typically most of the time those probations are revoked but yet reinstated, either under similar conditions. So it's kind of you need to comply with conditions. That is the admonishment from the court. Now, it's multifaceted how it protects the community. To me, the graduated steps and sanctions that the probation parole bill would advise for kind of an automated system, I just don't have a lot of value in adding more community service potentially. And community services is good generally, but if we've got an offender who's not complying with certain terms and conditions that are not threatening, not related to public safety, nonviolent, I don't necessarily agree or need an automated system to impose more conditions, such as, well, now you need to do 20 hours of community service. We're already struggling to have this offender comply with conditions. I don't see the value in mandating more or additional conditions, or 5 days, or 3 days of jail, or 7 days of jail. To me, and I don't want to identify it as inherently bad, it's just, it doesn't value the offender, it doesn't value the system, it doesn't protect my community any more or less, and it's, I would argue, more burdensome and onerous on the offender. And so my concern is there are different levels of supervision for different types of offenders. And I think it should be left within the discretion of the defense attorney, the prosecutor, and the judge in that district on that particular case to determine the outcome of certain violations and not be handcuffed or restricted by what's proposed in this bill. If that makes any sense.
It does.
Because if I'm going to agree to a probated sentence up front, and that's my only opportunity under this bill to impose a incarceration or jail time, and if I don't do it at initial sentencing, I agree to probated sentence, but then need to jump to these hoops, I'm less inclined now to agree to a probated sentence. There are a lot of aggravating and mitigating circumstances to how I'm going to structure a plea agreement and agree to sentences at the outset.
Okay. Ben, I want you to respond to that.
Yeah. So first of all, I think Mr. Montoya and I agree on a number of things. And one of the things I think we struggle with is that there are social issues out there, behavioral health issues and substance abuse, which underlie a lot of the crimes, not all of them, but most of the crime that takes place. And I think one of the things we need to do is sort of define what public safety is. And that might be a longer program, but really when we're talking about what the criminal court system is supposed to do, it's supposed to keep us safe. What does that mean? It means that there are certain laws that have been passed that you're not supposed to violate. Don't hit people, don't harm people, don't steal things. Also, don't walk around with drugs in your pocket. Don't drive around with drugs in your car, don't have drugs in your house. Now, the use of drugs can lead to people committing crimes, sometimes against their families, sometimes against other people, and those can be really serious crimes. But the possession itself, for instance, doesn't necessarily harm anybody other than the person that has them, and even then, it's not necessarily, it doesn't necessarily harm somebody. I mean, up until just about a year ago, it was illegal to possess marijuana. Now it's not. So we've changed this as a society. The point is that we've created the criminal court system, unfortunately, is one of the only ways to address these social issues. And it is underfunded for all of us. It is understaffed. And so there is a bureaucracy of the courts and the jails, and we struggle to keep up. Our problem, and one of the things we've tried to address with this bill, is to make things move more quickly so that it actually serves the community better.
I see. And so I want to talk some about the notion of moving things like drug addiction and other sort of societal problems that we have away from the criminal justice context. What are some of the solutions? And I want you both to weigh in here. What are some of the solutions that are outside of this context, and why are those not prioritized?
We are not well situated, the criminal justice system, to deal with social problems such as addiction. And what is the purpose of the criminal justice system? Incapacitate, rehabilitate, deter. Not a whole lot of rehabilitation is available, but the law enforcement assisted diversion are monies where we, as a county and a criminal justice system and law enforcement and for the prosecutor's office and the defense bar, outline criteria of offenses that are nonviolent, whereby an offender qualifies at the point of potential arrest to a caseworker to help address their issues, whether it be socioeconomic, mental behavioral health, substance misuse disorder. And those are the types of programs where I'm all for it. Don't give addicts to us to fix, because we're not the fixer. We serve those three prongs. And when it becomes violent or dangerous, I think that's the best purpose of the criminal justice system, is to incapacitate.
Sure. And when you talk about things like LEAD, right? Like New Mexico is sort of behind the rest of the country in terms of like developing LEAD programs. We've seen those in other places in the country. You just mentioned only 7 counties here have one of those now. My real question, what I'm trying to get at, is why haven't we made those kinds of prioritizations among policymakers and others, given the statistics here, given where we stand on things like overdose death rates? What are the points of failure there?
Sure. Well, so to deal with these issues, again, we've talked a little bit, and I've mentioned what I consider the bureaucracy of the court system, which is a pretty clunky mechanism to address social issues and individuals with problems. Often our clients and people that Mr. Montoya is trying to deal with, whose family members sometimes come to him and ask for help. Generally on the spectrum of like arrest, and in the past a lot of the contact has been with police, right? Somebody calls the police and they show up. So I think in New Mexico we're not necessarily behind the rest of the country. Unfortunately, the country as a whole is pretty far behind on what we do. And there are some programs. Law enforcement assisted diversion is a good one. Albuquerque Community Safety Program here in Albuquerque, which is designed to, when somebody's in a mental health crisis, send out somebody that is not a uniformed officer, somebody who's trained in mental health. And so there are some really good programs, I think, in New Mexico going on. But what we're concerned with as a public defender is getting people to somehow get better, to not impact public safety, to not hurt other people or themselves without running them through the bureaucracy, the court system. And at the end, or in the middle of the court system, is jails and prisons. And our jails and prisons are in such bad shape, I believe, that they often do more harm than they do good. And that is why we've looked for ways to keep people out and or shorten the time that they're in there.